Welcome back to the Law News Network, everybody. I'm Aaron Keller, and we're getting ready for our coverage of the Michelle Carter sentencing in Massachusetts that's coming up in about half an hour. I'm here for the time being, along with Caroline Polisi, but we have some other guests on hold, and Dan Abrams will be taking my chair in just a couple of minutes. This is a case that has attracted a lot of attention nationwide and even internationally, because it's a case involving a young woman who was a teenager at the time who pressured her boyfriend, Conrad Roy, into suicide. That was enough for prosecutors in Massachusetts to charge Michelle Carter with involuntary manslaughter. She chose to be tried by a judge rather than a jury, and the judge decided to convict her. There are many sentencing options on the table before the judge. This could be everything from a probationary sentence to a 20-year prison sentence. But I think the overriding notion of the day is going to be that she's being sentenced on a youthful offender statute, and the goal of that law is to help guide someone, not to punish someone. So based on that, I'm wondering if this is going to be a very, very light sentence. Do you agree, Caroline?
I agree with you 100%. I think it's very indicative of where the judge is heading, that he let Michelle Carter out on bail pending the sentencing. You know, a lot of times judges will immediately remand defendants that are convicted of crimes that have prison terms. So I think absolutely the fact that she's a juvenile here definitely points to perhaps the criminal justice system not being the best place to treat her. Maybe perhaps some sort of a mental institution or some sort of type of psychological help that she should get.
Okay, we've got a lot of information up on LawNewz.com. For those of you following along on the web, I wrote a piece saying that I believe that this conviction is sound under state law, and I run through the litany of reasons why. Ron Blitzer, our senior editor here at LawNewz.com, completely disagrees with me. He thinks that this thing should be knocked down on other grounds, and it raises an important issue, Caroline, because a lot of people are saying, hey, wait a minute, we've got free speech in this country, and really what she did was speak. She didn't provide anything. She didn't give him the means to commit suicide. She didn't, she didn't provide anything. She just used words, and she wasn't even physically with him when it happened. And I can understand that argument. A lot of people are saying, you know, hey, is this enough for a conviction to stick on appeal? I think in state court it will. The question is, do we get a federal habeas corpus review or some constitutional challenge?
I think we are definitely going to see this overturned on appeal. Something has to happen here, because this is not right. This conviction should not stand. I love you, Aaron, but I agree with Ron on this point. You know, the ACLU of Massachusetts has come out really vehemently opposing not only this conviction, but this prosecution in the first instance. There's no reason that prosecutors should have brought this case. Involuntary manslaughter, they're trying to square a circle here. They're using her actions and trying to fit it into the involuntary manslaughter statute. Remember, there is no assisted suicide statute in Massachusetts. If the legislator had wanted to do so, it could have. So you know, really important points that the ACLU is making here, that this is a slippery slope. We are infringing upon freedom of speech, freedom of expression, and it could have a really chilling effect on potential end-of-life discussions between loved ones. You know, Aaron, you and I are friends. If I tell you to go jump off a bridge, am I going to be looking over my shoulder then for handcuffs? I mean, it's just ridiculous.
Well, Ken Belkin threatened to do the same thing to me yesterday, so now I've got two of my guests who want me to go jump off.
No,
now,
I don't.
Which bridge is it? Is it
no.
the Brooklyn Bridge? Is it the George Washington? You know, which bridge? You tell me.
I mean, we're laughing, but it's really not funny when you think about it. In a democratic society in which First Amendment rights are paramount, this is a very scary proposition that we are entering into, and I, for one, do not think that this conviction should stand.
Well, now constitutional grounds were not part of the analysis that I wrote for LawNewz.com, so those of you who want to check it out, certainly I encourage it. The bottom line is this involuntary manslaughter statute in Massachusetts has got a ton of wiggle room. You can drive a couple of freight trains through the language in it. It says that it requires an act, but failing to act once you put someone in danger can constitute a failure to act, and that is an act, and you can get in trouble for that.
Yeah, and the judge got himself tongue-tied too when he was saying that Michelle Carter created this toxic environment, that then she created that duty of her own to act. I mean, It is utter nonsense, Aaron. The fact is, these were text messages. This young lady was 30 miles away from where the suicide took place. And it's just ludicrous. It was neither involuntary nor a manslaughter. I think Ron made that point. It just makes no sense, and it's a legal fallacy that they're bringing this prosecution.
Well, the competing theories will continue here. So one thing that we want to mention as we set up for this hearing at 2 o'clock is that we're expecting at least letters to be read into the record that were submitted, according to local media reports in Massachusetts, by the victim's aunt, who is calling for the maximum prison sentence of 20 years, and by the defendant's father, who says she'll feel bad about this for the rest of her life and she should only get probation. Now, it's not uncommon, Caroline, for victims' family members to come forward and say, we want a max sentence. And these are understandable statements. Do those things actually mean anything? Do they sway the judge, or do you think this judge knows exactly what he's going to do before he walks into that room?
In my experience, judges typically know the sentence that they're going to give prior to hearing any of this evidence. Look, the fact is he's received these letters. He's read the pre-sentence report issued by the probation office. He knows the prosecution's stance on it. He knows the defense's stance. He likely has his decision already in mind. That's not to say that perhaps he could be swayed by some of these obviously moving statements that are going to be made, but sentencing is a whole different ballgame. There's so much more wiggle room involved in sentencing. It's a much more emotional exercise. And so I think that what this judge is going to want to do, as in any sentencing, is balance aggravating factors and mitigating factors. She has a lot of mitigating factors here. She was a young woman, a juvenile, as you stated, and she herself had many, many mental health issues. So I think that's going to be a big point that the defense is going to want to harp on. I really see her coming out with just probation in this case.
I want to bring another guest into the conversation now. William KICKHAM is a criminal defense attorney in Boston, and he's been kind enough to join us while he's spending a little bit of time in the Cape Cod area, as I understand it. So, William, welcome to the LawNewz Network.
How are you, Aaron? Good to be here.
I'm well. So what's your take on this? You practice in Massachusetts. My read of this involuntary manslaughter statute is that, as I said before, it's got a lot of wiggle room. Do you think it was enough to get a conviction in this case, or do you think that this should not have been a conviction at all?
No, I'm in your corner, Aaron. I was there long before we spoke. This statute clearly allows for this. I've analyzed this in several media and written about it on my blog. Words alone do not bar this type of conviction. And the involuntary manslaughter statute, which is what she was prosecuted under, clearly allows this. My prior observation, someone had told me earlier that this was just text messaging. It wasn't. These people were in each other's presence constantly. They were frequently around each other. She did this in person. She did this on the phone. She did this via text messages. She did this in several conversations. She encouraged him repeatedly. He tried to back out once before, and she punished him for it. He tried to back out during the act, and she told him to get back in the car. This kid took a vulnerable person who she knew was suicidal and she knew was troubled, and she not just encouraged him to commit suicide, she repeatedly pressured him to commit suicide. In fact, after he died, her entire focus was on herself. She held a gathering in her own town for herself. The evidence here is replete that this conviction was justified. And the ACLU is up in arms about it, but my reading of the statute that she was prosecuted under allows for this prosecution. And words alone do not bar this type of conviction. I'll offer you an analogy, a metaphor, which we lawyers work by, but if you're taking a walk by a cliff, and you see a blind man using a walking stick, and he asks you which way to the parking lot, and you know that it's left. You tell him to take a left to go to the parking lot. But instead, just because you have, a depraved heart, you tell him to take a right and walk 20 feet, knowing that if he does that, he's going to go over the edge and probably die. Now, if you do that in Massachusetts, that's sufficient for involuntary manslaughter. And that's allegorical to what occurred here. You know, I think that she will be sentenced under a diversionary model. I don't see punishment here as much as redirection. But we're talking today about whether or not she could be convicted under this statute in Massachusetts. And my reading is that she could.
Yeah, and you know, the judge made many of these points, and your analogy, I think, fits based on my analysis of the state law. You practice there, you're the expert far more than I do, but I still disagree. Do you think there's going to be some federal issue or some constitutional issue that's going to run up against these Massachusetts laws?
Yeah, I don't agree. I think that, you know, with all due respect, I think that analogy, while potentially helpful and elucidating, is not entirely accurate. In that case, there's no action on the part of the man. In this instance, Conrad Roy was a very troubled young man, and if you read over all of these text messages, he had the desire to kill himself. He talked extensively with Michelle Carter about his desire to commit suicide. I'm not saying, and I think that everybody on my side is repeating this, she is a morally reprehensible human being. It's horrible what she did. I can't even read the text messages. I get sick to my stomach reading them. However, it's not criminal conduct. Now, whether or not it fits under, you know, you can square a circle fitting it into the involuntary manslaughter statute, it shouldn't be allowed to be prosecuted, and it's a scary state of affairs in this country if we put someone behind bars for up to 20 years for speech. It's just ridiculous.
Well, I want to go and listen to a
Carolyn,
little.
but with all due respect, you said that the metaphor doesn't fit. It's a metaphor that actually indicts her even more, because, you know, the metaphor that I offered where the blind man doesn't know which way to go, and for depraved heart you tell him to take a right and over the cliff he goes. This situation that we're dealing with is even worse. You say he was suicidal. That's correct. Twice, however, he backed out of the suicide, and she punished him for it. Twice he backed out, and she still pressured him to do it. I mean, this is a situation that is not only replete with someone who is morally reprehensible, but someone who is legally guilty of this. And I've heard a lot of my colleagues speak about this case, and when they defend her, and they say that this conviction wasn't justified, they open by saying the obvious, which it's no stretch to do, and big deal if they do it, which is they acknowledge that she was morally reprehensible. Then they follow with, but she shouldn't have been convicted. Incorrect. Legally incorrect, morally incorrect.
Well, where do you draw the line then? I mean, where do you draw the line?
This young boy to kill himself, and didn't stop until she was successful.
Well, the line would be drawn if you look at the case law. She should have done something when he tried to get back into the truck. That's the one point at this that everyone, the appeals court that looked at the sufficiency of the indictment, the judge who handed down the conviction, they all laser focused in on that one moment in time. And that's where they're saying this is where it went absolutely too far, because he was in a situation that was inherently dangerous. She had more or less led him there by helping him understand how carbon monoxide poisoning works. She told him how to set the truck up. Yeah, she didn't physically do it, but she walked him through the processes, and those text messages were all in evidence. But what they're honing
in on... And Aaron, what does her action... You point out something very, very prescient and very important here. What do those actions in her not helping him when he tried to get out of the truck, telling him to get back in, instructing him in beforehand how to set up a hose to fill the cabin full of carbon monoxide, what do all those actions speak to in evidence? Answer, one word, intent.
Yeah, and she was prosecuted under an involuntary manslaughter statute. It doesn't fit the statute.
However, her actions did not constitute voluntary manslaughter, but they did meet the statutory requisite for involuntary manslaughter. Clearly.
We just have a fundamental disagreement. I think, again, in the law favors bright line choices. I think that with evidence of this nature, where there is actually no physical act, it's just over text message when this young woman was 30 miles away. I mean, again, think of it in the context of having a very emotional conversation with a loved one talking about end-of-life care. I mean, you want to have a modicum of privacy, and
that's a completely different argument.
It's not. It's not.
No, it is. And the
Carolyn, the animus that was present in this case would not be present in your analogy of a caring, loving family member or friend talking about someone who's terminally ill with cancer.
You know,
that is completely inapplicable here.
And I'll jump in and say, well, let me settle this right once and for all right here. The Supreme Judicial Court, when examining the sufficiency of the indictment, said flat out that this is never to be construed as having anything to do with physician-assisted suicide counseling situations. I think that they nailed that coffin shut in that sufficiency of indictment decision, and they never want anybody to go there.
I'm not saying it's the same situation. I'm saying you're getting one step closer there. You have to concede that it's in the realm of possibility that these two issues could come into play at one point. You have to concede that.
I would not concede that because I don't think that it could.
It is so remote and so inapplicable as to cause, completely needless and deliberate, confusion of the issue. This is just not applicable to that situation.
Well, we're going to see more and more of these prosecutions sprouting up then. I mean, this is going to be, if you're going to criminalize this conduct, you're going to see a lot more prosecutions for this kind of thing. And people better be nervous about what they say, what they text.
That right line angle very clear. I mean, for someone who opposes this person's conviction to say this conviction is going to open the door to people with assisted suicide counseling to be liable, that is absolutely ridiculous. And the court made that clear.
Well,
now,
let's
if she were prosecuted under the voluntary manslaughter statute, it would have been more difficult. But she was prosecuted under involuntary manslaughter, and this conviction is entirely appropriate under that statute.
I would agree with that point as well. Now, look, I mean, the standard here that the Supreme Judicial Court is going to have to look at if they face this thing on appeal is whether or not the conduct was wanton or reckless. And I'm guessing that that's the language in the statute that would prevent, for instance, yeah, that's exactly it. Yeah. I mean, so how, Caroline, would you argue that an end-of-life care decision conversation would meet that standard of wanton or reckless conduct?
Well,
because
if the conversation veers into, do you think I should do this? Yes, I do think you should do it. I wanted to do this for a long time. Okay, well then today's the day. Why don't you do it? It's not that much different. I mean, I agree. Again, I'm not defending this young lady. I'm not defending her.
It's not that much different?
Well, I'm saying the actual words used, why not do it today? I mean, that is essentially what Michelle Carter texted to Conrad Roy that day. Do it now, do it now. So yes, I can see this. I can see a slippery slope argument here.
Oh, Carolyn, you are trying to create something that doesn't exist here. You really are. I mean, to posit the idea and the notion that someone who is terminally ill and dying with cancer and has a conversation with someone would in any way equate to the animus and the depraved heart conduct that this defendant exhibited for months and months and months on end is absolutely ridiculous. It just is.
I mean, I can think of a number of hypotheticals which would, veer you in that direction. If somebody harbored hatred or resentment towards a loved one, secretively over years or something. I'm just saying that it could get there. It could get there.
But the states that have these, physician-assisted suicide cases,
doesn't.
Okay, but the states that have them have ridiculously clear statutory standards in play to alleviate a lot of your concerns. They say, look, you need to have two independent physicians agreeing to things. The physicians are the ones that prescribe the manner of death. It's not somebody sitting in a Kmart parking lot in a vehicle with a hose hooked up to the tailpipe of a device. I see apples and zebras factually here.
I'm not saying it's not apples and zebras, but I'm saying it's in the same realm of possibility. I'm saying it gets you there. It gets you one step closer.
Absolutely illogical and absolutely inapplicable. And the court's decision itself made that clear.
Well,
it's absolutely inapplicable.
Well, let's talk a little bit about the First Amendment applications of this, because this I think might at least, it's a stronger hook for a complaint on appeal. And look, I mean, I've been a journalist most of my life. I'm a big advocate in favor of strong First Amendment protections. But even I looked at this speech and said, if we're going to criminalize some kind of a speech, this is getting awfully close to the kind of stuff that I personally don't have a big issue with there being some punishment for, because it might not be incitement to riot, and it might not be some of the other speech that can get you in legal trouble, but it gets so close that
It's perversely close. I mean, and this situation, you know, the ACLU. I'm a criminal defense attorney, and I fight tooth and nail, skin and bone for my clients, defending them. But the ACLU has never found a situation where they cannot object to any form of speech. They don't want any restriction at all. I mean, for the ACLU to posit the idea that this is going to inhibit on free speech, it's just ludicrous. I mean, again, let us focus on the facts that we are dealing with. We are dealing with a person who spent months and months and months pressuring someone that she knew was weak and vulnerable to kill himself. And when he once backed out, she punished him for it. When he tried to back out again, she punished him again, and she did everything she could to get this kid to kill himself, and he did kill himself. And now we have the ACLU saying, well, if you allow someone to counsel someone who's terminally ill, God knows we make it into freedom of speech issues. I mean, this is just ludicrous. It's just, you know, look, if anyone wants to posit an argument that is reasonable and cogent and logical, I'll listen to it. I'll hear it all day long, 8 days a week. But these arguments in favor of this defendant are absent any line of legal reasoning and any logic and any common sense whatsoever, on a legal level or a moral level.
Let me throw this argument on the table here. Some people are saying that this statute is a little bit vague, and I thought that argument might stick, at least in broader context, but the courts in Massachusetts have rather universally found that this involuntary manslaughter standard, which from my perspective seems a little bit loosey-goosey, and it covers a lot of stuff. The courts in Massachusetts have stood behind this at every single challenge. I wonder if whether that standard is just a little bit too loose.
I don't think, given the construction of the statute, that it's too loose. And I will point to the fact that there's never been a prior prosecution under it that's been problematic. I mean, had this defendant been prosecuted under the voluntary manslaughter statute, I can see there would be problems. But it's involuntary manslaughter, and words alone are enough. A physical act is not required. I mean, the whole constellation, the totality of circumstances that surround this case, beggar the mind for why someone would say she shouldn't have been convicted. I mean, the only person that I can imagine who would say this person should not have been convicted is just some civil libertarian that will not see the light of day.
Well, we're gonna wrap this part of the discussion. We're going to wrap this part of the discussion right here because Dan Abrams is present and accounted for. He's going to be sitting in the seat in just a couple of minutes. But while we wait to make the switch for this hearing coming up in about 7 minutes, we're going to listen to some of the defense's arguments in closing at trial.